well, this is my third time in the last month. I was moving a daughter home from school and then came to graduation, and she went to Shepherd, so I've been here quite a lot. It's always a nice town. So we're going to keep talking about legislative and manual updates, and we'll just jump right in. Okay, the first thing we're going to talk about is the pettit juror qualification forms, and I understand that it took the circuit clerks 3 years, 3 tries to get this bill passed through the legislature. I think it's a good bill, and it really works. It's very effective and really serves the purpose. The first thing you need to know is there used to be a provision that said that names of jurors and juror qualification forms were subject to public disclosure. Somebody walks in, you had to give it to them. Now there's a lot of information, as you know, on those forms, like addresses, things like that. And there was a concern about harassment, concern about privacy. So that is no longer the case. That provision was simply struck from the law, and then it was added with the provision that details how you can review the forms. So the first thing is who can review the forms upon request, and that's counsel of record. And by implication, if you have a pro se party, not just somebody who's pro se, but somebody who's pro se who's going to be trying a jury trial, then they would have the same ability to review forms. So that's something to keep in mind. How do they ask for this? The statute says upon request, and John and I talked about this. This is just an oral request to the clerk. They walk in, I'm trying a case next month, I want to see who's on the panel, or whatever, at whatever point you pick the panel. I know counties are different as to when they pick. So there's some time limitations on this, and it's this type of access. It's from the time of selection as a prospective juror until the trial's conclusion. So you might have somebody mid-trial wants to look at a form. They are allowed to do that. Once the trial is over, once there's, closings are done and it's all said and done, they cannot access except by filing a motion or getting a court order, and I'll talk about that in a minute. So that's pretty different. That's different from what you had. Now, once the trial is concluded, a counsel, a lawyer, a pro se party has to get a written court order to look at juror qualification forms. And there are a certain amount of case law that deals with jurors who perhaps didn't disclose a felony, didn't disclose certain relationships, and those things, they may come up, but they need to have a written court order to come to your office and review the forms. In addition, the judge is supposed to deny any request to review the juror forms in writing, and they're supposed to do that within 30 days. Now, it may be that an attorney will file a motion, but I can also see them just making an oral request in a post-trial hearing, and at that point, then perhaps you'll just have a court order without a motion. Another thing that's a little, not tricky, but maybe needs to be considered is that this bill didn't make juror qualification forms or names of jurors confidential records and didn't really specify access. So it may be that somebody else might have a public interest in these forms. If they want to get a court order, they can get a court order to access the forms. I mean, and again, they would have to state a legitimate purpose, but that should be a decision that's made by the court. One other thing about this bill is the provisions in the new statute deal primarily with qualification forms, not names of jurors. And it may be that names of jurors have some public interest. I try to think about it. Perhaps a reporter, perhaps somebody who's writing a book. I really don't know. It's somewhat of an open question, and there's no guidance. The statute's very new. So if you have a question like that, I would ask your presiding judge about whether anybody should be allowed to have that information. So that's my advice for handling it. Con and I talked that over. So now, Kathy Gadsden sent me a copy of the juror profile, which is the Supreme Court's juror management software. And it's really just a summary of information from the clerk's manual. How many of you guys are using this software? Some. Yeah, and Kathy sent me a sample of it. Basically, it's a summary of that information. And if that's what you wanted to provide to counsel of record when they're preparing for a jury trial, I think that's an acceptable method. And if you go back and read the manual, there's a reference to having bar cards that are prepared. And it's basically that same sort of information. As that, it's just an electronic version. It's subject, though these forms are subject to the same sort of access as a juror qualification form. It's really the information that's protected, not the form per se. So that's how we come down on that. And it's important to think about that and decide how you're going to allow people to review the forms themselves.
So the profile sheets that we prepare to
Yes.
give to the attorneys will become like the questionnaire after the trial. They will not be, but they're still available for other trials. So,
if you have if you were to allow an attorney to review that information in the clerk's office, okay, and they can review it up till the end of the trial. At the end of the trial, then unless they're trying another case, they're not allowed to have access. They can't come in and say, "Can I have that?" Yes.
If we allow them to review it, do we also allow them to take notes? And if they take notes, they've got a copy of it anyway.
I
mean, they could do that or not.
Right, I think they could. I think they could take notes. I don't think they have to have some ability to prepare
Right.
for a jury trial. It's a big deal.
I mean, they get copies. Usually they get copies of those. They'll pay for copies
Right.
of those, so they have them anyway. I mean,
Right. Well, that's a really good question.
well, I have them sign an affidavit that just tells what they can use that information for, that I'm
Well,
giving them
that's-
the copies.
That's a very good idea.
Like what the
And-
code says they're allowed to use it for, and that's it.
Okay, the question, yes.
No, I'll wait. I got another question.
Okay. The proposed solution was to have attorneys sign an affidavit as to what they could use the information for. And I think that's a good way to deal with it. Yes.
If can the request be larger than the jury that's actually pulled for the existing trial? Are we talking, we're not talking they can pull our entire jury pool.
Your pool for that term, yes. Well, if you have it drawn for that,
If they're
yes.
selected as
The entire term.
selected as a prospective juror, and there's a little wiggle room, and that's wiggle room. Not wiggle room. Wiggle
Room.
Yeah.
Wiggle worm in there.
Yeah. The worms are in there. So there is a little room. But until they're selected as a prospective juror,
Right.
is what
It
the
depends, like the
Assigned to
civil.
a jury panel.
right, assigned to a jury panel. And again, if you just have
But if it's
you select the jurors for the term, I wouldn't think you could
Once you
just come
pull
in.
it small.
It's the panel
Remember
themselves.
when they asked?
Yep.
Depends on how much it costs. But I make them sign.
Yes, that's it.
Teresa, we send out, I kind of like the jury profile, a little bit different. We send out a second questionnaire that goes into a little more detail. It helps the attorneys during the voir dire. Like, have you served as a juror before? Are you currently in any court cases? Have you been a witness? And just a little more detail that helps the voir dire. And that's the questionnaire that we let them have. But once we know, like say if I have a panel of 80 jurors, they can get all 80 of those second questionnaires because they don't know until the day of the trial who's going to be on their panel. So they like to have them ahead, especially the prosecutor's office, so they can look for the.
Right, and again, I think that's allowable under the statute. It's a little bit unclear. I mean, I had that, and I figured this was going to be the questions. From the time they're selected as a prospective juror till the conclusion of the trial is how the statute reads. Yes.
There's no, for instance, if I were an attorney and came in and got a copy, or I was doing a pro se thing, and I got all the jurors, all the information. Now I have that copy, if the trial's over. Well, I have that copy. It's mine, I suppose. If I wanted to make 100,000 copies and distribute it for free, this has nothing to do with that, does it? Or does it?
That's why I have them sign the affidavit.
Sign it, right?
Because we had people do that and then contact the jurors later on because they didn't like the jurors' decision, their verdict. So I have them, the code tells you what they are allowed to use it for and what they're not. So I just make a copy of that.
And make them sign.
Have them sign an affidavit, and I write the trial date, have them print their name and sign it, and that way I know I disclosed it to them, and that's it.
And again, she indicated that she has to sign an affidavit, and really the idea is to limit harassment.
Right, exactly.
And specifically, there was concern about, I think that we had a question a couple years ago about a prisoner who just wanted juror profiles, and that is, you know that's post-trial. Yeah, and that's post-trial, and post-trial should not be allowed. Now, there's legitimate reasons for post-trial access. Again, you look at challenges to jury, somebody who sat on the jury. There's a fair amount of litigation on that. Most of the time, that's when you really have the questions about jurors. And there's a fair amount of case law, again, about jurors who didn't disclose a felony is a big one. Jurors who didn't disclose a relationship with one of the attorneys. So that's what's tends to happen. Okay, are we good? Okay, we're good to go. All right. And then my final slide, this bill would includes its effective June 4th, 2014, and grand juror forms are confidential, and they can only be released by written court order. So again, that's a heightened level of confidentiality, more so than the pettiture form. So these are good changes, good developments in the law, and I'm going to turn it over to any questions on that. Okay, I'm going to turn it over to John, and he's going to talk about HIV test results.
Okay, good morning. Yeah, I think that the whole jury form issue grew out of an on-camp several years ago. I was also sitting right after his conviction, wasn't Kathy? He made a request for, he wanted all the information parts on his jury form. And so, and under the statute at the time, absent a court order preventing that, the clerk was obligated to turn it over. So the statute hopefully will avoid that problem. Won't avoid what the bug scenario about making copies of it. Perhaps affidavit should have happened.
At least it protects us.
What's that?
At least it protects us. What they do with it is on.
At least they do their problem, right?
Right.
You're having a hard time hearing?
It's easy, Joe.
Yeah.
That's a lawsuit.
I'm going to talk here briefly about the statute that's been around for a while, but there's new rules, new legislative rules on it, and that's the HIV testing the Age-Related Medical Testing and Records Confidentiality Act. It's been around since 1988, so you all are probably familiar with handling the orders that result from those tests and the results that result from those tests. But the changes in the legislative rule this year have given some new emphasis on a couple of things. First thing is that back in '88 when it was passed, until 2011 when it was amended, it only applied to those defendants convicted of certain sexual offenses. The offenses covered by the Act are any defendant at the time convicted of sexual abuse, sexual assault, prostitution, or incest. Okay? They amended it in 2011 to include any defendant charged with one of those offenses. Okay? So it moved the clock, it moved it much earlier as far as the process goes. The statute also applies to juveniles. By definition, juveniles were included in the coverage of the Act. And juvenile charged with a delinquency offense that was, the underlying offense was a sexual crime. The legislative rule, which goes into effect, or actually went into effect May 11th, makes it clear that juveniles are to be covered under that. And what triggers it is that the whole Act covers a lot of consensual testing, but there is a section about mandatory testing. When a juvenile or adult is charged with one of those offenses, then at their first appearance before the court, they are to be ordered to submit the testing within 48 hours. Okay. Typically, their first appearance, of course, is going to be in magistrate court. I don't know how many, it varies across the state with juveniles, whether they make any appearance before a magistrate, acting as a juvenile referee. In how many counties do juveniles only appear in circuit court, either for detention or, okay. So, those kids would be in your court to begin with, but most of these adult defendants would first appear, of course, in magistrate court. The magistrate, and we've just obtained, I think, approval from the Supreme Court that those forms were revised for the magistrates to order the HIV test at the first appearance. Then the way we wrote the rules, and I was on the committee that drafted this legislative rule, those test results are to be submitted. We were trying to figure out where they would end up. We needed them to be sent one place, and so we ended up saying that the results are to be submitted to the magistrate clerk. Okay. Now, if the case has been bound over to circuit court, and the magistrate clerk no longer has the file, then the magistrate clerk is to submit the test results to you, to your office, okay? Then the tricky part here is making sure that at the time the test results are submitted or to the magistrate clerk, they are to be provided to the prosecuting attorney so that the prosecutor can inform the victim of the offender's test results, and to the defense attorney so the defense attorney can inform the offender. Okay? So the trick is finding out whether the magistrate clerk has done that at the time you receive the file. If the test results are in the file, can you assume that the magistrate clerk provided those to the prosecutor and the defense attorney? I don't know. Hopefully there'll be some record that those were provided but I think you're gonna have to work that out county by county as far as assuring that the results were provided to the prosecutor and defense. Now, if that's,
John, did that new rule change about the copies? Because those have never been provided before to the prosecutor or the defense attorney. The only person we can send them to is the Commissioner of Corrections, unless the court orders is something different.
yeah, Betsy's question is the rule something new because they've never provided anything, the test results to anybody but the Commissioner of Corrections? And that's the way the statute read for years, was that when a defendant is convicted, they shall be tested, and then the results shall be delivered to, assuming they're sentenced to prison, to the Commissioner of Corrections. Now, it changed in 2011, and we tried to get the legislature to update the rule for, well, it's going on 3 years now, and they finally did it, okay? So the law changed 3 years ago, but no one's caught up with it until now. So now it applies much earlier to when somebody is charged, and then you have to provide it twice. Once to the prosecutor and the defense counsel, and then if the defendant is sentenced to regional jail or to corrections, or if it's a juvenile and the juvenile is sentenced to DGS custody or some other out-of-home custody, you're going to have to provide it to DJS or DHHR. It's unlikely that if they're convicted of sexual assault, sexual abuse, it's not likely they'll be committed to DHHR custody. It's possible, I suppose, but in all likelihood they would be committed to DJS custody. So, yes, it's been different for 3 years now, but it's no one's caught up with it.
Our 2013 manual still didn't tell us to do that, so that's why I'm asking is, so the new rules are saying that we're to send those copies? Or you say the 2011 statute says that?
The 2011 statute only provided, the problem with the 2011 statute, if I think back, was that the way they changed the statute, they said the court having jurisdiction to try the criminal offense was to order the HIV testing. Okay. The problem with that is, typically the court trying the criminal offense is the circuit court. So they wanted it done within 48 hours, but they really named the way they worded the statute, it was wrong. We tried to get them to change the statute last year, and that didn't go through, so we resorted to changing the legislative rule to fix the problem. So, does that answer your question about it? Yeah, the manual wasn't changed because we didn't have any answers before that. The manual will change this year, but the regs make it clear that it's initially going to be the magistrate who makes the order in most cases. Unless it's a juvenile appearing in circuit court for the first appearance, then the circuit court should order for one of those offenses.
And that's proactive. The prosecuting attorney doesn't request, he wouldn't even know the request or she. We provide that the moment we know, or have that test result.
That's right,
Okay.
right. There's a provision in the rule that says the prosecutor can ask for it, and actually can ask for other tests for other sexually transmitted diseases. But as far as the HIV, this is all to catch up with the federal regulations, frankly. And so, so it's focusing on the HIV testing. But when we wrote the rules, we also put a provision in the prosecutor could ask for other sorts of testing. But it is supposed to be automatic. The judge or the magistrate is to order it at the first appearance, and the results will appear in your file. Okay? Now, I don't know if I skipped over the slide. I'm not paying attention to the slide very much. Sealing, and you all can help me on this if you've got a better answer for it. The provision, the rules and statute require that the HIV test be kept confidential, the test results. So you have to seal them in the file. Okay. So the way we've written it in the manual that's coming out here in a couple weeks is that you are to individually seal the test results and place them back in the court file. Does that give anybody any heartburn as far as how to handle the test results once you provide copies to the prosecutor and defense counsel?
Shouldn't they be sealed when they come up from magistrate court?
Betsy says, shouldn't they be sealed when they come up to magistrate court? Yes, they should.
Could they not just write on the outside of the envelope, since we always have to put confidential report filed and sealed, couldn't they show copies too?
Yes, and then Betsy's saying, if the magistrate is, the clerk is doing their job, they should seal it, and they should also write on the outside of the envelope, they have provided copies to the prosecuting attorney and to the defense counsel. That would be the ideal solution, I think, in most every county as far as how to handle it. But if they come up unsealed, or they come up with no indication of who they were provided to with anybody, then you're going to have to check with the magistrate court to find out. Okay. Now,
Is there going to be a problem if we open a magistrate sealed document to verify that's what's actually in there and it's been served if it's not documented anyway?
Brenda asked if it's going to be a problem if you all open a sealed magistrate envelope. I don't think it'd be a problem. I think if you just write on there, we unsealed it to verify the information, seal it back, sign it, and you're done with it. Okay? Now, once they're convicted and sentenced, if they're sentenced to corrections or to regional jail, or if it's juvenile DJS, then you are to provide a copy to the custodian. Okay? There's nothing in the rules about how to do that. We feel like there's a danger if you just stick it in with the sentencing order that's being transmitted. So what we're recommending, and what it will say in the manual, is that that ought to be transmitted separately to corrections or to DJS in a separate envelope, sealed with the confidential indicator. Okay? Does that present any problem?
Not to us, but if anybody, well, I'm not getting into that. Regional jail's gonna then try to get those two things back together again in some fashion.
Well, yeah, and they can get it
Well, I
back
hope
together.
they can.
But,
They'll call down.
yeah, I think that's the best way to handle it, and hopefully that'll work out. So, did I cover everything? I think I did.
Yes.
Okay, any questions? I'm going to turn this back over to Teresa here. Any questions on the HIV? Her question is, which is a good one, what about scanning the document? Can we open it to scan it? Yes, you can and should. And I'm going to defer to Matt on how to.
Secure, just like it's secure and think about secure. Secure meaning
Okay, Matt says as long as the scanned copy is secure and no one can get to it except for authorized people in your office, then it's fine to scan it. That's a good question. And a pretty good answer. Anything else? Okay. Be careful with this mic.
Well, I'll try to not dismantle the microphone. Well, I'm going to talk to you about the new filing fees that are effective July 1st, 2014. Might be something that you want to put up a sign about. The first thing when you're working with these fees is you have to remember that fees and costs are really subject to a statute. And what the statute says, they don't make a lot of intrinsic sense, and if you try to do that, you'll make some mistakes. And in fact, I had worked on part of the manual, and then I went on vacation, and I came back and reread the statute, and I was like, oh, I got that wrong. So hopefully you'll benefit from some of my misreading. The first thing is that the filing fee for plaintiffs and petitioners has increased to $200 effective July 1st. And that $45 increase goes to the fund for civil legal services for low-income persons. And that was actually a fund that was established as part of marriage licenses, and $5 of every marriage license goes into this fund. It applies to civil cases and miscellaneous family court cases. So again, the question, establishing a parenting plan when people haven't been married, that's what it's going to apply to. What it's not going to apply to, and it's important to know that too, is annulment, separate maintenance, and divorce, which remains at $135. And it also doesn't apply to medical malpractice plaintiffs who are still on the hook for $280. And it doesn't apply to the modification of family court orders, which are $85 and $35. So that's for the filing fee for plaintiffs and petitioners. Okay, and it's important to keep in mind what your party is, whether they're a plaintiff or a petitioner. Now, for defendants and respondents, they have now a $200 filing fee to file a counterclaim, a cross-claim, a third-party complaint, or a motion to intervene. And I'll tell you, it doesn't apply to family court any family court cases, but it applies to those civil cases when a defendant files one of those pleadings. Again, counterclaim, cross-claim, third-party complaint, or motion to intervene. And our recommendation is hopefully the CCIS will be amended so people have to disclose whether they're lawyers will have to disclose whether they're filing a specific type of claim like this. And these are fairly common. And also, in the meantime, clerks are going to have to review, because many times you file an answer and maybe on page 6 there's a counterclaim. So that's where it goes. Now, the entire amount of the defendant's filing fee goes to that fund. It's not a mirror of the plaintiff's filing fee, which is divided into multiple funds. So that's something to keep in mind. Because I remember I first thought, oh yeah, it'll just be the same. And then I went back and read the statute. It's like, no, it's not the same. So something to keep in mind. Again, it doesn't apply to any family court cases. Okay, so if you have somebody who wants to counterclaim, maybe somebody filed an irreconcilable divorce is different than somebody else counterclaims for adultery, that's free. They can counterclaim all they want. It's also just a reminder, a medical malpractice defendant only gets a $200 fee. They can file as many as they want. It doesn't apply to parties with fee waivers. Now, a defendant who files one of these types of claims only gets hit with one fee. So they could file a counterclaim, a cross-claim, and a third-party complaint, and they're not going to pay $600, so they're going to pay $200. So once they're on the hook, they're good. They can file as many as they want. So, any questions about that? And we thought it might be good to do a couple hypotheticals, and John is going to do those hypotheticals.
Are you saying that once filed and paid, after that, there is no filing fee? Did I hear that right? Or?
Yeah, a defendant who
Right.
files a counterclaim in the initial pleading, And then they might file a cross claim later on. They are not going to, once they pay that filing fee, they don't pay another one.
Okay, we're gonna go, just to highlight some of the important differences now, we're gonna go through, I think, 3 or 4 hypotheticals. But Teresa's right, the way the statute is structured, the way they changed it, it makes it a bit confusing about when it applies, when it doesn't apply. Because the statute, which is 59.111, it's always started out with except as provided in subdivisions 2 and 3. Subdivisions 2 and 3 are the medical malpractice special filing fee and the special fee for divorces. Okay, and by reason of just necessary implication, 3 and 4, which have to do with the normal support, custody, parenting plan issue, and the expedited, they also continue to have their own fee. So the first hypothetical is unmarried mother, the minor child wants to file a petition for a parenting plan to set child support. So what do you charge her? It'll be $200. It falls in that category of a miscellaneous family court because she's unmarried and she hasn't established, it's not a modification, this is her first occasion to establish that. Yes?
Most of those cases usually turn out to be waiver stuff.
Yeah, well, any time it's a fee waiver, it becomes beside the point, okay? But if they don't have a fee waiver, then it's, and we're trying to break this down in the manual, which you should have before July 1. And, but there's a few sort of tricks and turns to this that we're hoping to highlight. Now, the second hypothetical, I'm not going to read it to you, you've probably read it already. What do you charge him for his child support? 0. Okay, because it's the way they wrote the statute, even though this special exception applies to mom as far as $200, in the proviso about, or in the section, the new section about defendants and what you charge them, it says you don't charge any defendant in any family court case a filing fee for a counterclaim or something like that. But yes.
Is that because he's a male?
All that.
Is that because he's a man?
The father is a male.
The father is a male, yeah. Yeah, it's because it's a male.
So if there was an unmarried father at the top and the mother of the minor, would it still be 200 and 0? She's wanting to know if that's a sexist.
Yeah, it would still be 200. Yes. Okay. Same hypothetical. Okay, but the parents are married. Now Teresa wrote this, and these are real truths. So, but the parents are married. What would you charge for?
So Teresa wrote this, not the legislative
You still charge the mother, not the
It would be a divorce, okay, because she's filing, and so it would be $35.
$55.
The question is, if she's wanting to not file for divorce and just custody, it would be the 200. And that is, yeah, that's right.
March, December, May.
Now, if you're not if the mother is not filing to divorce, but for custody, it's $200. Is that what I heard?
Right, and I really should have said divorce in this scenario. But I don't think you're gonna get a lot when you're not filing for divorce.
Right.
And the father's filing again. files an answer with a cross-claim, counterclaim, and a third-party complaint. What's the filing fee for this?
$200.
$200, yeah. Okay.
Let's do
And
Rich.
LSF takes the whole $200. Okay, so their legal services foundation. Fair amount of money on this. Does anyone know that? Do you know the history of this?
We can't hear you. Microphone.
Oh. Do you know the history of this? Who was the proponent of this increase in filing fees? Do you
I
know?
think they came from, from Lyon County.
Barbara Evans
Barbara
Fleischauer.
Fleischauer. She's the one that always wants the extra fees.
Oh, so it was her.
It wasn't any of us.
Yeah. Dwight?
John, does this go to legal aid, or where does that money?
Yeah, it goes to legal aid.
Okay.
So it'll be a primary source of funding for legal aid. Okay. So just anybody who complains about it, just give Barbara Fleischauer's name. Right?
There you go.
Okay, another hypothetical. A grandmother wants to file a motion to intervene in a minor's guardianship case in family court. What's the filing fee on that?
There isn't.
John, what did you say about that?
Yeah, we do need to know
Malpractice, if they filed an answer?
Oh, the defendant who files an answer in a medical malpractice and he files a counterclaim, cross-claim, and third-party claim, it's still only $200, even though he files 3 types of defense claims. It's still, they only get charged once. Okay?
285.
No, 280 is for the plaintiff in a medical malpractice, but a defendant in a medical malpractice who files one of these claims only gets hit with the $200 fee. And that's why I'm saying it's a reading of the statute, not what you think will make sense. You really have to.
Yeah,
Get
so-
with the thing, but just in $200, not 280.
Right.
Right.
If there's
For
a
the-
defendant,
The plaintiff still gets charged $280 for filing the medical malpractice. But under the statute, the defendant, and it's any defendant, if a defendant in the car wreck case is filing a counterclaim, cross-claim, and a third-party claim, then they only get charged $200, even though they're filing 3 types of claims. That's the only point we're making. Yes, we will put these hypotheticals with the answers.
We'll put the answers in the back.
Put the answers in the back.
or down at the bottom.
So, what's the answer to the first hypothetical here? Grandmother?
0.
What's that?
0.
0. Very good, Nuts, yes. Because
The clerk told me.
a motion to intervene,
Good job, Bud.
motion to intervene is lumped in with the defense, counterclaim, third-party claim, cross-claim, and if it's a family court case, you can't charge any file. Okay?
So then she would have a filing fee in the second, to pay the 200.
Into an open case, yes. And now, what if grandma waits and files her motion to
She shouldn't be able to
intervene
file it.
after the case has been, and once in a while they're removed to circuit court?
200.
Still 0.
200.
Yep.
200.
Oh, because it's not in family court.
Because it's not family court.
Okay.
So, it's in, some guardianship cases are never family court.
But how does grandma know about the confidential case in family court?
How does grandma know about it? Well, she.
We didn't tell her.
I think that's it.
Motion is that would be really.
There's gotta be a lot
We
of
didn't tell her.
questions. Oh. I just threw this in for good measure, because I don't know what impact this is gonna have on this whole issue. It's 3A. This was changed a few years back to require multiple filing fees for plaintiffs in any sort of civil action. Now, how many of you all do what the rule actually says to do, which is to forget about the exceptions? That if there are the example that Teresa and I discussed the other day, if there were 3 college students unrelated in a car wreck in Morgantown, they file a civil action against the driver of the other vehicle. Would you actually charge them? I mean, you're supposed to charge them each a separate filing fee if they're unrelated. But do you actually give them a separate civil action number?
No.
And document it as a separate civil action?
Some do, a lot don't.
Some do, a lot
Would
don't.
that not change whether you can charge or not?
We give them a number. Now the judge may consolidate them, but we give them a number.
You give them a number and
And if the judge consolidates the case, that's
Right.
fine, and usually that happens, but they paid a fee, we give them a number.
so, depending on how you do this can impact what, let's say the defendant then files a counterclaim saying it wasn't my fault, it was the driver of the 3 college students car fault. And they file a counterclaim. Do you charge them $200 or do you charge them $600 because you have 3 separate civil actions? I don't know the answer to that. And that's going to have to...
Depends on if they file it before it's consolidated or after.
I think if you give them separate civil action numbers and document them as separate civil cases, and they're not consolidated, I think there's a pretty strong argument that a counterclaim would cost the defendant $600 instead of $200. She's accusing lawyers.
I'll second that.
What? She said that lawyers will come up with all sorts of tricks to avoid paying that. That's true. I suppose, some lawyers. But, yeah, you're going to have to watch, and hopefully the CCIS will be amended so that they have to provide on there what kind of claims are asserted. Yes.
I mean, think about that, where it could go. What if it were a bus? Or what if it were a group of guys going to see the game and they had 18 people in there? You're going to charge them 18 times?
Yep.
Yeah, I know, it gets tricky, it gets tricky, so it's, or asbestos cases, I think, a lot of that.
Believe me, they don't like it.
They're not related. So we don't run out of time, I'm gonna turn this back over to Teresa. And we'll be around, we'll be here for the round table this afternoon, and then we can deal with any other questions.
Okay, the next section of the presentation, we're really talking about sort of FYI stuff. They're not going to, most of these next few bills won't be things that are implicate what you do as directly as collecting filing fees. But I thought it was good for you to know. Effective June 12, 2014, and effective dates are all in the legislative memo. I didn't put them in the PowerPoint too. But bail bondsmen will have to charge a minimum bonding fee of 10%. However, they can either have it paid in full when the bond is issued, 3% at the time when the bond is issued with the balance due. And then there are a few things left in that bill that require them to give receipts when they have collateral or security given when they post the bond. So they have to get, it's really targeted towards bail bondsmen. They're going to have to keep better records. No, this is not something you have to do. It directly affects bail bondsmen and their business. But I thought you all may give some questions about it. Another thing is that community corrections programs are now authorized by statute to conduct pretrial release programs, and there's some fees. They can do a supervision or participation fee is $7 a day. If they're convicted of an offense, they can be charged upon conviction $30 per month for participating in that pretrial program. That is all payable to the community correction boards, just like other community corrections fees, but you might want to be aware, because I can see defendants not knowing where they have to pay that, they were 3 months on pretrial supervision and they have a $90 fee, and they're going to say, where do I go and pay it? The community correction board. There's also a new article, it's 11F in Chapter 62, that really just authorizes counties to do basically a standalone pretrial release program as opposed to not part of community corrections. They'll be under the governance of the Supreme Court, and I believe any fees that they might charge will also go to the community correction boards. I don't know how much they'll be implemented, yes.
You're talking about the local in-county community corrections board.
That's
It
correct.
meets once a year.
Right.
That's actually, in effect, going to be done to whoever is running your community corrections program, right?
Right, that's right. And
Under
then
the board.
it'll go then to the fiscal agent for the county, which
Okay.
is usually the sheriff.